Respected audience, this is Naushav Khan, attorney at law, adjunct professor law. This is part 4 of our series of program on medical negligence. As I have shared that the incitement I received for this series is from multiple questions raised by the audience during Family Con. This is an annual event of Pakistani Association of Family Physicians. They hold an annual national conference, and the distinguished professionals in the field of medicine and surgery and other disciplines of medical dispensation, they take part being keynote speakers in this conference. And I had the veneration and privilege to be the part of this recent conference as keynote speaker. And my topic was medical negligence, and I received multiple queries that encouraged me to record this series of program for the students of medical law, especially those practicing lawyers who are working in the field of medical negligence, and especially healthcare providers as well as healthcare establishments managers who are managing their healthcare establishments. And this program is also of extreme help and assistance to the medical students, because they do study medico legal, and the knowledge of medical law can also help them to safeguard their lawful and legitimate interests while practicing medicine or surgery or other disciplines in Pakistan. Now, I'd like to move on to the topic, and that is medical negligence. In previous part, we have discussed civil medical negligence, and we have discussed that compensation can be one of the aftermath or one of the outcome of negligence if established against a healthcare service provider or healthcare establishment. Whereas the consequence of criminal negligence, these are grave in nature. And so we will discuss different aspects of criminal negligence. First of all, if the negligence is very gross, very severe, which led to death of a person, the patient or legal heirs may go to the police for gross negligence. In Pakistan, we have very often observed that the legal heirs, they lodge a complaint against the healthcare service provider or healthcare establishment, and on account of this complaint, FIRs are lodged against the doctors. We will discuss at length in our next part that what are the legal remedies or what is the legal recourse available to the healthcare service provider or healthcare establishment to safeguard their lawful rights in case an FIR is lodged against them. But at present, actually, if the negligence is gross in nature and the result is the death of the patient or a severe injury, that can entail the consequence that the doctor can be held responsible for committing gross medical negligence. Furthermore, during the operation, if the doctor has left the scissors inside the abdomen and finished the surgery and came out, or operate varicose vein whereas patient was admitted for the operation of gallbladder. These are the examples of breach of duty of care by commission, and that is the doctor has committed an act which resulted into medical negligence. There is one part, and that is breach of duty of care by commission. There is a breach of duty of care by omission. We will discuss that in our next part. Have a blessed day. Thank you very much.